Excellent. So welcome to all of you. How many of us are we? I'm not sure, at least 6 as far as I can see from the screen. I'd like to welcome you on this panel on remedies. My name is Paul Nihul. I'm a professor at the University of Louvain originally, and now a judge at the General Court in Luxembourg. And we are welcoming a fantastic panel of 4 persons, 5 in fact, because Jasper is also presenting the paper with somebody else who is not there. But then we will hear respectively Sebastian Payer, then we will hear Jasper Slice, and then we will hear Francisca Weber, and then Ignacio Garcia Perrote Martinez. I would suggest that we start, guys, you have about 12 minutes per person. I will try to be very respectful but strict at the same time. And I'm looking forward to hearing your ideas. Please do not speak too quickly and share your PowerPoint presentation if you have one on the screen. Yes, Sebastian.
Well, thank you very much, Paul. I hope you can hear me all right. I'm just setting up the screen share. Just give me a second. Go. Okay, so can you all see my screen share? It's all right now?
Yes.
Fantastic. Good. Thank you very much for inviting me. I hope you can hear me okay. We've had some issues at the beginning. Let me know if that's how the sound quality is okay. So what I'm trying to do in this, thanks for the invitation to present at ASCOLA. It's really fantastic. There were fantastic presentations this morning already. So what I'm trying to do in the next 12 or 11 and a half minutes is talking about private remedies in digital markets. And so this is, the focus is really on injunction claims. And the background, so what I'm trying to explore in this paper is, what is the role that private action can play in an increasingly digitized economy? What is the influence that they can have in enforcing competition rules in digital markets? And I have picked, for obvious reasons, I'm based in the UK, I have picked the UK.
I'm sorry, Sebastian, we can't hear you very well. So what I think I'm going to propose is that, Sarah, can you share the screen from Sebastian? Can you do that? And Sebastian, can you turn off your video, and then maybe by concentrating on your voice, we'll be able to hear you well. Is that okay?
Are you going to screen share? Are you going to screen share my presentation?
Yes, Sarah is going to do it, the assistant in charge of this.
Sorry, I don't have his presentation. Could you?
I can do it. I can do
Thank
it.
I'm terribly sorry. So as you've probably seen on my first slide, it's a beautiful building with a very good internet connection. Unfortunately, I have not been able to be in that building for 3.5 months now. So I have to live with my crappy internet at home. So apologies for that. Okay, so can you move to the? Yeah, I can see. Yeah, I think I can see it. So, okay. And that's okay for everyone. Then can we just move to the next slide, please?
Yes.
Go to. Okay, so sorry, just need to make sure that I can see what I want to say. Okay, so the background of the whole of this paper is that we have had a fair number of challenges in digital markets. We still trying to get our head around how these markets actually work. And especially 2019 has seen an awful lot of policy papers, expert reports on what these challenges are. And most of these reports came to the conclusion that the assessment of market power can be tricky, especially in two-sided markets. Just infrastructure and data pose some very challenging problems for competition authorities. And from the purpose of this paper, most importantly, the lack of speed. It's something that's quite challenging. So, and the point here is that in these markets, if a firm reaches a particular size, we see this kind of phenomenon of ping, where the winner basically takes the entire or most of the market. And that, of course, makes it very, very difficult to challenge that position. So entrants, firms that seek entry into the market, find it very, very difficult. What is interesting to note about all of these reports is that they mainly talk about public enforcement. So what they're looking at is what are the enforcement issues from a public point of view. I mean, substantive law applies to public and private enforcement, but when it comes to the remedies, there was really only discussion about public enforcement remedies. So generally the speed of public enforcement, there were some considerations about a better use of interim remedies, so to try to act faster on a temporary basis. There were also some discussions about judicial review, and of course, I mean, all of this ties very heavily into the question of substance. Paul, can you move to the next slide, please?
Yes. Here we are.
Thank you. So what I'm doing in this paper, and this is really just the essence of it. So I'm trying to find out what are the lessons we can learn from this experience. What comes out of it is that firms seek and believe in both digital and non-digital markets, primarily against the use of market power. So they rely heavily on Article 101. We don't really see that many Article 101 cases, and to my knowledge, there's not a single case where firms sought an. So these counter cases seem to be more that seems to be picked up by follow-on cases, follow-on damages cases. The second lesson that comes out of the UK experience is that let's just take a very cautious approach. The reason why I'm mentioning this is because in a lot of these expert reports, there was talk about type 1 and type 2 errors, false positives and false negatives. And the concern being that in the past we were too worried about false positives, so finding an infringement of competition law when there is none, as opposed to false negatives, where we just think that that's actually legal, where in reality it's probably illegal. The third main point of my analysis is that there is probably more guidance required when it comes to the assessment of abuse conduct, and I'm probably not the first one to say this. There is one example which we're going to talk about in a minute, where we have where we talk about anti-competitive effect, what we now refer to as self-preferencing, and the judge is having a hard time really trying to figure out where the abuse is. So he did a really great job, but it's also clear that more guidance would be helpful. And the fourth key message of the paper is that it seems to be that firms are reluctant to use the essential facilities to seek access to competitors' facilities. So, and that these days they would also include data. And the question here is, why is that the case? Why are parties more inclined to use allegations of discriminatory behavior rather than essential facilities? Could you just move to the next slide, please? Thank you. Just a couple of points about injunctions in general in the English court, and then I will actually talk about the two cases that deal with digital markets. So in general, the injunctions are readily used and often also permanent injunctions. What is interesting to observe here is that injunctions are often a tool to facilitate negotiations. So what the court does is the court says, well, we think this is a breach of competition law, but they're not telling the defendant how to address the issue. So what that means is actually like a springboard for settlement negotiations or negotiations with parties. So in the public parking case, for example, they told Heathrow Airport that they cannot just send the competitor parking space far away from the Terminal forecourt because then the competitor could not provide the same valet parking services as Heathrow Airport. But they didn't tell them what the solution was. They didn't tell them whether they had to use competitor was supposed to be allowed to use the airport forecourt, or Heathrow Airport itself would move their parking services somewhere else. So that's supposed to be left out. So this is really just these are kind of insights based on injunctions in general. And now there are two cases The next slide, please. So this is the first one is StreetMap EU versus Google. There was an injunction claim by StreetMap, and StreetMap are now out of business. At that point in time, they brought a case against Google, claiming that Google has, by changing how it has actually moved traffic to visitors away from StreetMap's own mapping service. So both Google and StreetMap provide mapping services. Google in 2007 changed the way they show their mapping services. So if a user enters a search term that refers to some kind of geographic location or as a geographic search term, then they would show this one box with a thumbnail. And of course, the thumbnail contained a link to Google's own mapping service. And that was the basis of StreetMap's claim. If you could move to the next slide, please, Paul. So the questions then that the judge tried to answer in this injunction claim was that Google intended for closed competition, and they said no, that was just an unintended effect. That wasn't really the purpose of that new thumbnail, that box. And did StreetMap actually have to establish whether there are actual potential effects on the market for online mapping services? And here the court was very clear. That of course, if you bring a claim, you must show the effect. You can't just say that Google is dominant, which in this case was assumed in the search engine market. But you also must show that this is actually having some kind of effect. And this is where StreetMap's claim actually failed, because they were not able to show that this had an appreciable effect on competition. The court looked at visitors to StreetMap's mapping services before and after the introduction of Google's thumbnail, so the map with the thumbnail. And it turns out that there wasn't StreetMap's visitors, or number of visitors declined even before Google introduced that new service. And the court was just not convinced that Google was leveraging its dominance from search results to mapping services. The next slide, please. So what are the lessons from StreetMap EU versus Google? Some would probably argue this could have been an unsuccessful competitive claim. The judge looked at the quality of the mapping services, and the judge found that Google's service had improved over the years, whereas StreetMap services was not that much, or didn't see that much improvement in the same period of time. It was difficult to define the abuse. So the claimants actually based their allegations of abuse on the Microsoft case, and they said this constitutes bundling, so linking Google's mapping service to the general search results, that constitutes bundling. But the judge wasn't really convinced that that's bundling, and actually considered this self-preference. And as I said before, there was no appreciable effect on StreetMap's mapping service, so the case was thrown out. And here it is probably the reason why Google successfully defended itself is because they just simply had a better product, and consumers were interested in Google Maps rather than StreetMap EU. The next slide, please. And another interesting side aspect of this case is if you look at the Commission's Google Search shopping case, is also self-leveraging and StreetMap. What is interesting here is that it took about half the time for StreetMap to bring the case, albeit unsuccessfully, whereas the Commission needed about 6.5, 7 years. 6.5 years to bring the case. So, I mean, that's just one example. Whether that holds true for all cases, it's not. The sample size is really, really small, so that could be down to the individual case. The other difference is that in the High Court case, there was actually a very low proportion of traffic from Google to StreetMap, whereas Commission claims that in Google search there's a rather large proportion of traffic that goes to the comparison shopping services through Google, and that means by placing its own shopping service very dominantly on the search result page, Google prefers its own services over that of competitors. So this is like a maybe an interesting side note here. Can we move on to the next slide, please? So that's the second case, and that's more recent, and that's an application for an interim. And in this case, so what happened here is that Google threatened to delist an app from its Play Store and from App. And of course, the app developers claim that this is abusive behavior, and Google should refrain from doing it. So Google said, well, actually, the app violates our policies. So the problem here is that the app developers have come up with a concept whereby they would reward users for watching ads with the help of that ad. So they would get some credit points that they could use for shopping, this kind of thing. That, of course, selling, and then so they would sell, of course, information to advertisers, and they would kind of give a share of the profits to the consumer. That was the idea of the app. But of course, advertising is Google's business, so one can already see that there was a conflict of interest of providing a platform for a potential competitor in the market for advertising services. So Google was unhappy with that, and they tried to get rid of the app. And in this, so the question in these interim proceedings were whether whether there is a serious issue to be tried. Is there something of substance to talk about if we have a proper trial? And here the High Court said yes, there is a serious issue to be tried. So there is a potential that this is an abuse of dominance. And the second question, and that was very important here, is are damages an adequate remedy? So in the second step, what the court does is they look at whether this decision can wait until after the full trial, or whether there is a very important interest that makes it crucial that we actually have an interim remedy. Here, normally what wins the court is if there's a high risk that the claimant or that the applicant has to exit the market. And this was apparently one of the problems here. Unlocked had a business deal with a large retailer in the UK, and by being threatened or by being nominated for delisting from Google Play, there was a serious risk that they would lose the business contract, and that would also put at risk the entire app. Interestingly, shortly after they won the...
Give you 30 seconds.
Oh, okay.
If you don't mind, yes.
It still went into administration. And again, the problem here is how do the... So the point here is really interim remedies can sometimes work, even though ultimately the app developers didn't survive. Please go to my conclusion to the last slide, please. Thank you. Oops, is it?
No, it doesn't. Okay.
Right, there we go. So just the point I want to make with the second case, that injunctions are a very speedy remedy, so that sometimes they can be very, very helpful. Issues are, they're useful when it comes to access to market, keep markets contestable, and as the unlock case has demonstrated, they can actually keep platforms as regulators. We have, so far, I haven't seen any evidence of obvious false positives. And it is also interesting to note that it's a first step in further negotiating access conditions. The issues, and I've said this at the very beginning of my presentation, the issues really are that some theories of harm are unclear, and definitely more guidance is required to facilitate those private proceedings. Thank you very much, and thank you, Paul, for clicking through my slides.
A real pleasure, Sebastian. Something that I take from your presentation is this huge difference in time. In order to obtain a court judgment, you need to have 3 years apparently, whereas you need to have 7 years before you obtain an administrative position, and then afterwards the appeal, etc. So maybe there is room for discussion on this. But second, I'd like to give the word to Jasper Sluis, who is going to put forward, in fact, what he considers to be a disadvantage of the intervention by the judiciary in competition matters. That is the fact that judges tend to judge in all possible directions. Jasper, the floor is yours. If you want to share your screen, that would be wonderful. We can't hear you. Sarah, can you please open the microphone?
Yeah, I just unmuted myself.
Well, wonderful.
So you can see my slides and hear me speak?
Yes.
All right, excellent. So thank you, ASCOLA, for the opportunity to present this working paper. Welcome to my study in the Netherlands. And what I would like to discuss with you today is harmonization of faults in private enforcement. And that is, let me move on to the next slide. That is part of a research project that I've been working on with my former LLM student, Thomas, who is actually arguing a case today, so he couldn't be with us, unfortunately. The main takeaway for those who wish to know what this is all about. So we focus on a very specific lacuna we find in the damages directive, which concerns the still independent position that national courts have to consider fault in follow-on cases without fines imposed and standalone claims. Now, we find that this hampers the internal market and also induces forum shopping between jurisdictions, and hence we propose harmonization in the form of a rebuttable presumption of fault. Now, because this is such a specific aspect of private enforcement, we thought it'd be good to go back to the basics, really, and get everyone on the same page. And so start off with the role of fault in public proceedings. Now, it's pretty standard European Code of Human Rights doctrine that the severity of a sanction increases the level of free trial protection. And so consequently, in European competition law, we see that punitive sanctions, so fines, are conditional on intent or negligence, whereas so the non-punitive sanctions, so behavioral and structural remedies, do not carry a fault requirement. Now, having said that, of course, the Commission holds a very wide presumption of fault. So in Article 101 and 102 cases, intention and negligence have been assumed when the undertaking cannot be unaware of the anti-competitive nature of its conduct. And specifically in Article 102 cases, stemming from abuse of dominance as an objective concept, we've even seen case law allowing for abuse even in absence of fault. Now, from public enforcement over to private enforcement, I want to start out with Courage, which I'm sure many of you know was the first landmark decision establishing private damages claims and highlighting member states' procedural autonomy in addressing such claims. And this procedural autonomy was somewhat limited by Manfredi 5 years later, which required causality as a factor in damages claims, but not fault. And what we've seen since, so taking Courage and Manfredi together, is a divergence of the various national courts in private enforcement cases, and the courts in Luxembourg kind of scrambling to tie that all together. And this in itself may have caused some barriers or obstacles for efficient promotion of private enforcement, because the court rendered its conclusions in such negative form, right? So that in and of itself may have has created positive obligations in various member states, and may have created barriers to efficient private enforcement. Now, because of this, and the court scrambling to keep it all together, the damages directive was instantiated, which attempted to harmonize horizontal liability in competition law. Now, that was a step in the right direction, and many have argued, but particularly Giorgio Monti has written about this extensively. There are still quite a few open ends. And one of those open ends is what we discuss in the paper. That was a long introduction, but there we are. And that open end is independent fault consideration by national courts. Now, so where do we actually stand now when it concerns fault in private enforcement? So when can a national court consider fault independently? And that is obviously within the confines of the damages directive. That is given the principle of equivalence and how that has been instantiated in Regulation 1/2003. That is given commission decisions becoming res judicata beyond final appeal, and with respect to the provisions on punitive and non-punitive sanctions in the damages directive. So, tying that all together, we find that when we're looking at a follow-on claim concerning a commission decision with a fine, there is no opportunity for a national court to independently consider fault. Now, why is that? The intuition is really clear here, because there's been a punitive sanction. Fault has to be proven by the commission, and assuming the commission decision has been litigated till the final instance, that is res judicata. So you cannot reconsider that as a national court. Now, conversely, when we look at commission decisions without a fine, there might not necessarily be a fault requirement addressed by the commission, so hence the national court can consider that independently. And by the same rationale, a standalone claim allows generally for the consideration of fault by a national court, because there's no commission decision to work with in the first place. Now, so we end up with a situation in which member states can have diverging fault requirements in both follow-on cases without fines and standalone private enforcement cases. And currently even we see that fault is required for such a damages case in 7 member states and not in all the other ones. Now, we find that problematic, and we have then AG, currently Justice Wall with us, who argued in the Skanska case that the applications of different rules across member states on a fundamental issue directly affecting the right to claim compensation would run counter to both the level playing field for undertakings on the internal market, but would also induce forum shopping between jurisdictions. Now, so how to address these negative effects? And we've come up with 2 hypothetical options on how to resolve these diverging fault requirements across member states. And that is through harmonization, obviously. And the first option considers harmonizing strict liability. And the rationale here would be that anything other than strict liability would prevent full effectiveness of EU competition law. Excuse me. Now, this option admittedly requires some legal dexterity, but what you pretty much do here is that you interpret the conditions for horizontal liability in Manfredi as exhaustive. And because fault is not listed as a condition, you develop the argument towards a need to harmonize on the level of strict liability. And you could also borrow or transplant the doctrine of the sufficiently serious breach, which is a state liability doctrine in EU law. I'm sure many of you are familiar with it, which has been extended towards a private or horizontal liability of EU with direct effect. So here you would basically argue that a fault requirement would go beyond the principle of effectiveness of EU law. Now, the second option would be to to harmonize towards a narrowly rebuttable presumption of fault. And here you then would argue that you would presume fault once infringement has been proven, and only allow this to be rebuttable in courts in case of a genuinely excusable error. Here you would read Courage and Manfredi more in conjunction, and recognize that these cases do draw attention to degrees of responsibility for competition or infringement. And the same is actually holds for the sufficiently serious breach doctrine, which does leave room for non-liability in case of excusable error. Now, it may not be a huge surprise that we argue for the second harmonizing option, which is a rebuttable presumption of fault. It allows for stronger fundamental rights protection, and it underlines that infringement of EU competition law shouldn't necessarily or automatically amount to unlawful conduct from a civil liability perspective. Now, please note that all efforts towards harmonization will be heavily influenced by what's going on in terms of faults in public enforcement. So we shouldn't be looking at these two strands of fault case law in isolation. Now, because we have the opportunity here to discuss this paper with so many of you, and because it's still a working paper, we have quite a few questions that we would like to discuss with you. The first is, to what extent do you agree that the leeway that member states have in determining fault is that problematic to begin with? Second, do you think that maybe the option one of harmonizing strict liability is too much of a straw man's argument? Third, have we missed additional harmonizing options, perhaps? And would you like to share those with us? Fourth, maybe we could discuss how to harmonize here, right? So what will be the most appropriate route? So either through the legislature, so the damages directive and or regulation 1/2003, or rather the judiciary. And finally, more practical, we have about an 8,000 word paper now. Maybe you could help us think of an appropriate outlet to publish this argument. So thank you for your attention. Looking forward to your comments. And thanks again, ASCOLA, for the opportunity.
Thank you, Jasper. I'm not sure about the outlet, but what I know is that you may win the best junior or the best paper for respecting the time which has been allocated to speakers this afternoon. It's congratulations for this.
Thank you.
And so I'd like to remind everybody that you can use the chat, in fact, because that will be the basic instrument for us afterwards to animate the debate. I'm typing like crazy during your presentations, but I'd like to see somebody else also raise questions if you think it's appropriate. Now, I'd like to turn after these discussion on injunctions in the first paper and then on harmonization in the second paper. It has gotten my attention that you were alluding to pass on. And so I'd like to introduce the third speaker who is going to speak about this pass on thing in law and economics. I'm talking about Francisca Weber, Associate Professor in Law and Economics at Rotterdam Institute of Law and Economics, who just published or just finished our habilitation on this very topic. Francisca, you have 12 minutes. Can you, yes.
Thank you very much. So I will be talking about pass on in cartel cases, and I will thereby be reporting about outcomes in 3 jurisdictions, and I'll show you in a way the struggles between damages law and economics insights that judges face. So this is my overview. I limit myself to a cartel case in which purchasers along the supply chain pass on damage. And if we now, let's say from the direct purchaser's point of view, wanted to define what their damage is, what would be full compensation from their point of view, we would look at the overcharge paid, but here we would have to deduce the pass on that they actually gave to the next level in line. And we would actually also have to consider the volume effect, which is not, however, the main topic of my talk today. And I'll look into German, Dutch, and some Spanish cases here. So just very briefly about the economics of pass on, because I mainly like to talk about the interplay. So just very briefly, some main insights from economic research on pass on are that whenever there is an overcharge, there is typically also pass on. However, we cannot say anything about a typical pass on rate as the state of the art currently is. So there is a lot of heterogeneity with a view to the percentage that purchasers actually pass on. There are many factors that influences that in the end all link back to the demand curve, if you wish. And these different factors are also differently well researched. So not all the interrelations can be underlined equally strong from an economics point of view. Just to show the array of options that there are by some exemplified cases. So if we take the case that all the buyers are affected and there is perfect competition, well, in that extreme case, everything would be passed on, the whole overcharge. If all are affected and there is an oligopoly, we are probably most of the times in the range between 50 and 100% of pass on. And if there's low market coverage, if I'm the only buyer and there's perfect competition, well, then I can, in this extreme case, not pass on anything. There are many more insights to this, but I will leave it at that for today. One more dogmatic remark, if you wish, for the comparative legal side. If we look at this pass-on situation, there are 2 ways of thinking about it. We can either consider pass-on in the sense that, well, there was the overcharge, so I have paid too much, and then I passed something on, so subtracting this is my original damage amount. So we would immediately subtract it and say, okay, it has never come into existence in the first place. Let's say the glass was half full from, only half full from the start. Yeah, and then, and this is a huge discussion in particular in Germany, you could also look at it at a later stage, if you wish, by saying, okay, to start with, the damage due to the overcharge has come into existence, but later we might find reasons, normative ones, to subtract the amount of pass on again. So that would be typically these constructions of adjustment of profits. And in Germany, we very clearly allocate our pass on under these adjustment of profits rules. In the Netherlands, I put the flags on both sides, say the before and after situation, because the Supreme Court has rather recently explicitly said that it doesn't make a difference, no matter independently of burden of proof or how you do your calculations and how far normative judgments come into play. It is the same, no matter if we assess it immediately as what is the damage that has ever come into existence or later on subtract something. And for the Spanish case, to me, I think that the decision in the literature is not so clear yet. I would rather put it to the early stage, but maybe Ignacio can enlighten us later on if there's now a firmer scholarship that has developed in the meantime since I last looked at it. Right, so that from a dogmatic point of view. Okay, so then There have been many cases now, in particular with the trucks cartel, but also some others. And so in particular in the lower courts, we see now many judges that have to take decisions in cartel cases. And yeah, so in order to show you what they're weighing, I wanted to first outline what the limitations are that they are facing from a legal point of view. Let's say what are the boundaries that they can pass their judgments in, if the pass-on amount should be considered or not, or to what extent. And then in Germany, under this adjustment of profits doctrine, we require adequate causation between infringement and benefit. So this is what needed to be fulfilled, right? That the cartel was, in that sense, causal for the passed-on amount. There's a strong equity check, if you wish. Right, we can still deny a passing on defense according to German law if allowing that defense would go against the purpose of the compensation rule, right? So let's say a strong equity component that German law allows here. In Spanish law, as far as I could find, some refer also to the test of adequacy, and some in the literature refer to an equity control in one way or the other. So also there, the judge has some leeway from a purely legal point of view. And in the Netherlands, the Supreme Court made it very clear that no matter when we look at pass-on, the equity test that is applied is always the same. So that is, let's say, what the judge can maneuver with from a legal point of view. But taking into consideration that from an economics point of view, we also have many insights. The question is now how judges deal with this, how they integrate them. And so this is my main slide, if you wish. And I have, for time reasons now, marked everything in green, where we have insights from the case law that is in line with economics, and in red, where this is not the case. So it's not the main topic of my conversation, but both Germany and Spain, the courts have actually ruled on the fact that whenever there's pass-on, we also have to think about the volume effect, which is obviously in line with economics. And also there's a low court judgment in the Netherlands now where the volume effect came up in relation to pass-on. And then, what is in line with economics clearly is that the Supreme Court, I'm now starting with Germany, did in fact consider some of the market conditions when it was assessing whether pass-on defense could be granted or not. The court also very explicitly gave one example where pass-on is likely, namely the example where there's a white coverage, right? So many buyers are affected and there was workable competition, right? So that's exactly one of the scenarios I mentioned in the beginning. So far, so good. However, now we come to the red part. There are now many cases where, at least from an economic point of view, the reasoning is doubtful. For instance, the rational apathy argument that just because in lower levels of the supply chain, then nobody would sue, we shouldn't be granting the pass-on defense. Or the judges have been very critical about in how far this pass-on can actually be reflected in prices, much more critical than economists would be, right? Some judges even acknowledge that also, but so that was a reason to deny pass-on. We see in essence a categorical denial of pass-on so far. We also have some quotes of judges that were reluctant to see pass-on in regulated markets, again, not in line with economics. They also argued there can be no pass-on if there is no competition. Also, that is not true. Also, in monopoly situations, there could be pass-on. And then there's this judgment, which really is, well, was just one judgment in Germany, but it's spilled over to the Spanish market. In that sense, I spent a moment on it. So the judge argued that there was no identity or no congruency between the markets, between the truck that the buyer bought and then the transportation services that he was using it for. So I argued, okay, it was not simply selling it on, and this market is too detached And again, that is not in line with economics, right? Also, from an economic point of view, pass on can happen also into those prices, but the judge didn't consider that. And generally, German judges are very resistant to give numbers even to the overcharge, not even to mention pass on, which they, as I said, deny. Okay, a bit more quickly about Spain. So here, yeah, the judge also referred to the German judgment by the court in Dortmund about this congruency between the markets. So as I said, that is not in line with economics. And the judges in Spain have been much more brave and have actually made different attempts to quantify overcharges, much more than the German or the Dutch judges and many other judges in the European Union. But we have to say that the result is a bit of a different quality from an economics point of view. For the cartel cases in the truck cartel, the follow-on litigation, the amount of overcharge found varies a lot from 5 to 18.67%, right? So for a similar scenario, huge variation there. Okay, and in the Netherlands, for instance, I mean, there have been few cases, but in one, it was explicitly said that pass on a regulated market is acknowledged. So unlike the German idea here, I mean, the cases are not perfectly comparable, but just to give you an idea. Also, the Dutch make the irrational apathy argument, and so far there have been very few quantifications of the overcharge amount, and we haven't gotten anywhere near also here quantifying pass on, right? So I hope you see the struggle, despite the by economics, acknowledged general existence of pass on, and well, doubts about the exact amount, which would then need to be calculated, but it can normally assume that it exists. Yeah, in the case law so far, it is in essence categorically denied. Yeah, and many of the reasons given are not in line with economics. Now, I'm not saying that legal considerations and limits put are not important, but it is a bit awkward in a field of competition law where a lot of emphasis is put on economics, then suddenly to disregard economic insights, right? So I think we have to give justifications for when we do disregard economic insights. With the directive, economics, to my understanding, becomes more important, but won't be the exclusive criterion. It still leaves leeway, in particular when it comes to causality, for member states to put limitations. So my current idea is that really I want to encourage more joint thinking about this by legal and economic scholars to decide jointly, right, where to put the boundaries, or maybe even if the state of the art in economics also evolves, put some standardized scenarios with a tentative number for pass on to enable judges to actually decide upon these. So I thank you very much for your attention.
Thank you very much, Francisca. Brilliant presentation. Maybe as a judge, I'd like to pass on the responsibility for not raising this economic issue to the parties themselves, because if the parties do not come up with arguments raising this, we're not allowed to indeed integrate this in the judgments. So that would be interesting maybe to read, and maybe we can hear from this actually in the Spanish presentation that we're going to have now. I don't want to put stress on you, Ignacio, but maybe if you can say a word whether the parties somehow raised this issue or not. And I understand you will be actually put in the limelight because I understand that Spain has gone far actually in the reflection on this. So this is Ignacio Garcia Perote Martinez, PhD researcher and teaching assistant at Barcelona in Spain. You have 12 minutes.
So thank you very much. I'm trying to share the slide. Okay, so I believe that now you can see the full presentation and you can hear me. Yes, okay. I will try not to speak too fast. First of all, I would like to thank ASCOLA for letting me take part and present my research. This is actually part of my current PhD research. And well, I'm going to test and see if I am on the right track or whether I am totally or not. And I will try not to say the same as Francisca said, but I might answer one of her questions. I might. So let's start with a short story. We have several undertakings which decide to agree on gross prices. This might sound as the tracks cartel case, maybe it does. And whenever they sell the tracks, the buyers, they pay a price, a super competitive price, and the difference between this super competitive price and the price on a competitive market, that's the overcharge they are paying, and that would be the harm they are suffering. So once they are fined, So once this happens, the track buyers, in this case, they would pay this overcharge, and whenever they either resell the tracks or put on the fares of their transportation services, they have three options. They can either absorb the overcharge and without changing their prices, they could pass it back, which would mean reducing their budget in other options, or they could just increase their fares or increase their selling prices and pass it on to the indirect purchaser. So here we have somehow the basic outline of the issue. But this idea of passing on, that's not something that the company is free to do at any time, because they need to take into account several circumstances. First, which is the nature of the cost affected, then the coverage of the affected parties, then the market structure and the competition in that market, because depending on that, they would not be able to pass it on. As Francisca pointed out, the amounts of pass on depending on the coverage, then the elasticity of demand, and finally the buyer power. And here with buyer, I mean the indirect purchasers' power, and not just the direct purchasers. And this, before moving on, the pass on the pass on problem can happen either from direct purchaser to indirect purchaser, or between indirect purchasers among themselves. But I will just keep on the basic and easy scheme of just the three levels. So taking into account the damages claims in Europe are meant to be compensatory, the passing on argument has two sides. It could be used as a shield, which is the argument of the cartel member saying, yes, it's true that you paid an overcharge, but at the same time you passed it on, and thus the award that you are claiming is higher than the one you actually deserve. And as sword, it would be the offensive use, which would be and the shield seeks to prevent direct purchasers receiving windfall awards, whereas the sword argument, it is the way to grant legal standing to indirect purchasers and allow them to claim against to bring a claim against the cartel member, because the damage was passed on to them. I will, and here the rationale is to prevent cartel members from escaping liability on the one hand, and avoiding having harmed prejudiced parties without being compensated. And since many of the cases the claimants are direct purchasers, I will focus on the pass-on defense, and I will not enter into the sword use of pass-on, which is the indirect purchaser's claim. And just before entering into the Spanish legal requirements, just the pass-on argument, it is known in Europe and in the US. In the US, it was banned at the federal level, whereas in the EU, it was raised in damages claims against states and against the EU, and in claims for restitution for unduly levied taxes. And the courts did not ban it, but they accepted the possibility of taking it into account. And this is relevant because in Spain, the Supreme Court in a judgment in 2013 on the sugar cartel case, they inspired themselves on the EU Court of Justice case law and the travaux préparatoires of the directive, and they somehow outlined three requirements for the pass-on defense to be accepted. The first one, that there had to be a price increase in the downstream market, which is the normal pass-on. They also said that the burden of proof had to be on the defendant. Okay, that's also acceptable, but they added a requirement saying that there had to be no loss of sales. This was the pre-directive regime, and in the post-directive regime or in the directive regime, depending on how you see, on how it is exposed, presented in Article 78 of the Spanish Defense of Competition Act, the first requirement, the price increase, is accepted. The burden of proof on the defendant is also accepted, and that's part of the general rule or on burden of proof. Any argument that will render a claim unsuccessful should be on the defendant. But the lack of loss of sales, I believe that this is not, this would not pass the directive test, because this seems to infer that pass on can only be total, whereas the directive understands that there can be full or partial pass on. And because at the end you're allowed to claim for damnum Americans and lucrum cessans, and you may reduce the damnum Americans, but you may still have lucrum cessans, and that would not be. And if you are not allowed to reduce or claim that the damage did not exist, then you would be overcompensating, and that would be against the directive's objective. So seeing which is the currency, which is the abstract requirements of pass on, I will try to enter into three main hurdles or what I have seen from the case law, mainly the trucks cartel. So the first hurdle for defendants whenever they raise a pass on defense is identifying who the indirect purchaser is. And as Francisca already pointed out, some courts, mainly one of them, issued many judgments saying that the only relevant indirect purchaser would be the one in the same market where the infringement took place. However, after the second Otis case decision issued in December 2019, there seems to be a change of criteria, because the court acknowledged that it was possible to have an indirect purchaser in a related market and not in the same market as the one where the infringement took place. The second hurdle would be causation. Once again, one of the main arguments against the passing on defense was if we take into account passing on, that would mean that the harm would just go down and no one will be able to claim for damages. And then we should not accept it, because it will be the cost of the cost, and it will get into nothing. However, but at the same time, this would mean that we would be having claimants being awarded windfall awards, and that wouldn't be okay with the directive. So in many cases, the court said, okay, there's no causation link, because the company, not only will they just let the harm be lost among claimants, but they said, okay, there were many reasons for the company to increase the price. But if we take into account the court's the Court of Justice case law, and here the main example is the Kone case, the umbrella damages case, the court acknowledged that if the cartel is one of the possible causes of the price increase, that would be enough to grant legal standing for umbrella claimants. And I would say that we can translate this into a passing argument, saying that if the overcharge or the cartel is one of the causes for the company to increase the price, because as we exposed, and I am including Francisca, there are many reasons for a company to increase the price or not to do it. If there's one of the reasons, then it would be enough to take into account the possible pass on. However, the main hurdle is the quantification part. So it is true that defendants have to prove that there was pass on, and this includes identifying the claimant, the where it was passed on, and the causal relation. But they also have to have enough evidence to quantify the amount. The Commission proposes three different methods: the comparator methods, the passing on rate, and simulation, and they are mirrored to the ones required to quantify the overcharge. And the Commission prefers the comparator one. but the thing is, they have to actually quantify. And so far, the Spanish case law shows that many companies, they just say that the claimant did pass on, but they do not go one step further to quantify the amount, in part because their main argument is that there was no overcharge. So it could be incoherent to say there was no overcharge, but if there was, they did pass on. So that makes sense. Nonetheless, there was once again, there has been some decisions, and again from Valencia, where the judge said, there's the courts have the power to quantify if it was excessively difficult or close to impossible for the claimants to do it, to quantify the overcharge, the damage suffered. And I believe that this quantification powers includes quantifying the pass on, the amount passed on. However, this is possible provided that the defendant actually tried to quantify and not just said, according to the situation of the market, the company could have passed on, but they should try. And it is true that the main hurdle is finding the information, but we must take into account that defendants have a right to access, have the same rights of accessing to evidence that claimants do. So if one side can be asked to do it, the other can as well. So once we have seen the pass-on structure, the requirements and the hurdles in practice, and I don't know how I with the time, I will just jump into the conclusions, and I hope I did not speak too fast. Okay,
yeah, very good.
There's no slide with conclusions. So, so the first conclusion would be that the full compensation principle, or in my opinion, the full compensation principle requires pass on to be taken into account, just to prevent windfall awards and to prevent having damaged parties without compensation. My second conclusion would be that the requirements, the Supreme Court requirements, have to be either updated or parties should just take into account the new article 78, even though it might not be applicable until, it might not be applicable yet. And the third one, and the most important, some people claim that the passing on defense is going to be a way, it's a door to impunity and to having defendants not being liable for the damages caused by, through the cartels. But after seeing the different hurdles and how Spanish court managed to argue that there was no pass on, I believe that that's so far a fallacy argument, that the pass on defense is not going, or at least with the experience up to today, that it is not going to be an open door to impunity and to manage to have cartel members as just to pay a small fine and then live on and carry on infringing competition law. I hope that this last part was not too informal. I'm sorry. So that being said, thank you very much. And there you have my contact details. Thank you very much for your attention. And I hope I didn't speak too fast.
No, thank you, Ignacio. Very good, very well, very good job. And I wish you good luck for your PhD further. Now I have a small question. What is that? Facultad Dret?
That's the law faculty of the university.
Is that in how do you say that in English? That Barcelonish or no? Sorry, it's Catalan.
Yes, it just law faculty.
Facultad. It's in Catalan. It's the Catalan language.
Yes, that's in Catalan.
Thank you. Thank you so much. I'd like to also greet all of you, including Javier, that I see on his screen, and also my good friend Mark Patterson, I see a picture of him, and I actually a drawing. Maybe you can look at it, a drawing from his kids. But then he turned it up. Okay, that's fine. So I'm not going to be. Yes, he's there. How are you, Mark? Can you turn?
Well, Paul, thank you. And it's not a drawing by my kids. I did that.
I'm sorry about that.
That shows the level of my artistic skills.
Oh, they're very good, actually. Very good skills. Yes. Would you remind us,
Great
because
to see.
great to see you. We have you online now. What is it in the US as regards pass on? Can you remind us of that a little bit?
So in the US, you're not allowed to, the direct purchaser cannot claim pass on as a defense. And the indirect purchasers can't sue at all because they are therefore not damaged. Or I wouldn't say therefore, but in part because of the difficulties of calculating pass on. Although there was this Apple versus Pepper case last year in the Supreme Court that allowed what some people would say indirect purchasers to sue. And that's all federal law. The states have their own rules. And so under state antitrust law in the US.
Yes. Francisca, Ignacio, how would you react to this? Pass on not being allowed as a defense in the US? Either of you.
Now, yeah, the European approach starts from a very different premise. We want to compensate anyone at every level of the supply chain. I mean, there are many good reasons to argue why this is an illusion. And I agree that maybe some rethinking is necessary.
Would you think, if I may interrupt you, would you think that the rules on pass on in the EU, as well as all this damage liability, this damage directive, etc., is considered in the EU really as part of the enforcement policy at European level against cartels, whereas in the US it would only be considered as a way to compensate wherever it is possible to calculate the exact amount of damage to be compensated? Would that be a fair characterization, would you think?
I would, I didn't do thorough research on US law, but I would have said it's a much stronger emphasis on deterrence than in the European system, where this is more of a secondary goal. So what we really stress is this idea of full compensation of any level. And I mean, what I did read about the US is that whereas on the state level, you have the federal state level, you have this rule. In the states, partly it looks different, right?
Ignacio, what would you say?
Following what Francisca said, since any damage claims have, or comparing EU and US, they're like a threefold axis. We have compensation, efficiency, and deterrence. And while we in the EU take into account compensation over efficiency and deterrence, especially since damages are compensatory. In the US, as far as I know, damages are they are allowed to claim for treble damages. So the paper of deterrence and enforcement is more on the private side that in the EU, where deterrence is meant to be done by the public enforcement.
Would that be your understanding, Mark? Would you agree with that?
I think part of it in the US is, yes, certainly it's true that the Supreme Court has said that they think not allowing a pass-on defense is likely to increase the chances of a suit by the directly damaged, and so that that'll increase the likelihood of suit and therefore increase the possibility of deterrence. It's also true that in recent years, the Supreme Court has narrowed the possibility for, if we're thinking about indirect purchasers that are consumers, it's narrowed the possibility of class actions and the likelihood of class actions so much that it's not clear how much is really lost by not allowing those kinds of suits. And so it's true that formally, at least, the chance of compensation is less. Practically, it's not clear just how much less it is.
Okay, very good.
So those would be the majority of cases where the consumers are the direct purchasers themselves, in a way?
No, the majority of cases would be where the consumers are the indirect purchasers. My point was that in so many of those cases, for them to recover, it would have to be a class action likely. And the Supreme Court has narrowed class action liability so much, and so much of it now goes into arbitration anyway, and maybe the arbitration clause forbids class arbitration, that although in theory you do eliminate the chances for consumers to get compensation, practically speaking, even if we didn't have that rule, they still might not get compensated.
Okay, I see.
Okay. I'd like to ask, so we've seen, okay, maybe I can ask Sebastian. I saw that you had some questions to raise to the other members of the panel. Would you like to pick one of them and maybe to elaborate on this question? Whereas I'm taking a look at the.
I'm also very happy to say something about pass-on. Because,
we still have this. Sorry, we still have this issue of not understanding, not hearing you well. As a matter of fact.
you know what? I'm just going to. I don't know. It's probably my video. I just stopped playing my video. Is that better now?
Yes.
Okay, good. It's clearly my internet at home then. No, just on the pass-on debate. So one of the things that's also really important to look at is the cost of administering the pass-on. So when we think about, I mean, the MasterCard litigation in the UK is a perfect example where we now have claims from direct and indirect purchases. I mean, at some point, the court will have to figure out how much actually of the harm stayed with the retailers, and how much of that harm was passed on to consumers. So we have basically two different sets of counterfactuals, if you want. So we have one where the harm stays with the direct purchasers, and they kind of bring in their claim, and then there are the indirect purchasers that claim, oh, we also had harm. And MasterCard is, and Visa as well, or at least MasterCard is in a position where they have to argue both sides. So they would have to argue that the harm was passed on and harm was not passed on. So it's from an administrative litigation point of view, it's really, really tricky.
Okay. How would you direct your question? Who would you direct your question to?
All of them.
All of the audience. Okay.
I can maybe start. I mean,
Yes.
I agree, obviously, and I think there's. I mean, that was the European approach, the idea that we can have every level sue for themselves, and that leads to all the frictions that we are seeing. But there's also discussion in law and economics, each separately, of more holistic approaches, right? I mean, many economists would prefer, rather than to first have an overcharge, pass on, what about volume effects? What about the debt weight loss that we haven't even talked about yet for the final consumers, right? Rather than doing that artificially in separate steps, just have one calculation. And similarly within law, from a procedural point of view, you can also discuss if you shouldn't do it all in one procedure in a way, or then you can even discuss, but I know that competition authorities are hesitant to take upon this task, but that it should be rather done immediately there. Or I know that some colleagues have suggested that at least the competition authority would give a list of who all the victims were or things like that to facilitate claims. But so I perfectly agree with you. I think there were many, many frictions caused by the directive and also are existent in the previously existing systems that one could alleviate by joining procedures and calculations both more.
Okay.
Thank you.
Can we turn maybe to the notion or the concept of fault, which was enlightened by Jesper? In particular, I'd like to ask Christian Bergqvist, I think you had some issues with the, some questions that you wanted to raise in connection with this concept of fault. Is there one of them that you'd like to pick and explain, elaborate on? If you want to turn your microphone on, and then you can. Christian, we can't hear you. If you want to turn your microphone. Sorry, we can't. Can you turn your microphone on? Yes, turn it on.
Sorry about that.
Yes, that's good.
My comment is that for some odd reason, DG.com always love to claim that there is malicious intent in the decision. And except from predatory pricing, malicious intent doesn't really have any legal relevance, but nevertheless, they always articulate it. And, I don't really know why, but I think it's probably because when they come before you, it's easier to depict the company as, evil and guilty if there is some kind of malicious intent in it. And of course, eventually it will become some kind of legal standard outside predatory pricing.
What would you consider is the notion? What would you consider means the notion of malicious intent in law?
Let's take Google shopping. I've been working a lot on that. DG.com articulated all these emails circulating, underline that Google knows that there is a problem as an anti-competitive effect, and they do it more or less intentionally. My problem is that, a CEO should technically only have one thing on his mind, that is essentially to kill all the competitors. Otherwise he's not really protecting the shareholders. So there's something conflicting in actually putting so much effort into proving malicious intent. But my feeling is that it's much more easy to depict the company as guilty if you can also establish that they had intent. They did this intentionally and knowingly that it harmed the consumers.
That it harmed competitors or
competitors, and of course also indirect consumers.
Okay, Jasper, floor is yours to answer.
Well, I would actually like to move the discussion slightly based on a discussion that Sebastian and Christian were having in the chat box regarding whether there would be examples of cases in which national courts come to different conclusions because of varying fault requirements on similar facts.
Okay.
Right? And I'd be very interested to learn about circumstances in which we could find such a case, right? And we'd be looking at a case where an EU court has issued non-punitive sanctions, right? So that fault isn't automatically assumed, which is followed on by damages claims throughout the EU, which you would then be able to compare. And off the top of my head, that there aren't that many, right? There's usually fines involved that lead to follow-on cases. Or am I being myopic here? What are your thoughts?
So what you mean is that in addition to having an outlet to your paper, you'd like to have some assistance in terms of research. Is that what you're telling us?
I'm trying to help Christian and Sebastian to answer the question they pose, because it's a fascinating one.
That's right.
Yeah.
Sebastian and Christian, now you raise questions you have to answer as well.
Well, if I should start, Google Shopping is actually a prime example of that, because the Google Shopping, the European Google Shopping, and the British local map search case is actually more or less identical in the facts. It is self-favoring, but there was no decision in UK. It was acquitted, but there was a guilty decision on European level. And I think that the difference is that DG.com had more resources and time. It could establish a pattern of malicious intent, and it was anti-competitive, while the parties, the plaintiff in the UK case, essentially failed on that. So I think that the ability to put more resources, more time into it, and establish malicious intent was actually really drive the different outcome of the two cases. Because, technically the law and the fact is identical. DG.com cloud the matter because they intervene and says it's about shopping experience, but in reality, it is about self-favoring. You also have the hotel parity clauses. There was no malicious intent in them, as far as I understand, but it was not a particularly pretty outcome in every single jurisdiction. More or less went a different direction, and some of the case was overturned on appeal.
So that's a question. Can self-favoring be considered a fault when it comes to a discussion on remedies? What do you think, Jasper?
I'm hesitant. And simply for the matter that it is. Right. So, to what extent would you be able to self-favor a I mean, it is always intentionally, right? It is not something
you can say the M word. It's always maliciously.
Yeah, exactly, right? The problem here is, of course, that because fault has been so easily assumed in public proceedings, and it has become unwantingly complex in private proceedings, right? The public proceedings haven't been helpful here. So, but you're kind of putting me on the spot here, but I have a hard time seeing.
No, that's okay. But
Yeah, I have a hard time seeing why self-favoring wouldn't be intentional.
Now, let me ask, because I think that we are concentrating on the notion of fault, even though it's a panel remedy. Yeah. What kind of remedy can we try to construe in order to make sure that no firm, even with the dominant position, would self-favor one of its subsidiaries, one of its services, etc.? Does it make sense? Is that possible? I'm not only talking to Jasper. I see also the picture of Christian, of Mark, of Francisca, Ignacio, Sebastian. I also see Javier, Miguel, Ana, Sarah, Noga, Masako.
We have very interesting parallels in regulatory law there, right?
Yes.
So if you, for instance, look at infrastructure sharing in telecommunications and in vertical situations, so a wholesale access to broadband infrastructure, there are regulatory regimes in place that practically prevent self-favoring in terms of exclusivity, mainly, or predatory pricing related schemes by the wholesaler. So would that be an avenue to pursue?
I guess so. Mark, what do you think? You need a regulation then. Can you put your microphone on?
What do I think about whether we can have a practical remedy that would prevent it? I mean, as I just said in the chat, I mean, this is what treble damage is supposed to do, right? Otherwise, it does seem like all you're going to get is stopping the super competitive profits after a time. And treble damages, not only, I guess you could say, are there for because of the difficulty of discovering violations in, say, a price fixing conspiracy, but also for deterring any sort of anti-competitive conduct. But in anything but a sort of price overcharge, it's going to be very difficult to calculate any damages, let alone, you can triple some mysterious number, but if that number isn't at all valuable to begin with, trebling, it's not clear whether it's making things better or worse.
Okay, so we're still facing this difference between the US and the EU, where in the US you would put, I guess, the weight, or you put the emphasis on private remedies through treble damages, whereas in the EU, I would imagine it's more a structural remedy in the sense of having an administrative body imposing a new structure on the market in order to be able to avoid this kind of situation, to restore the structure of the market.
Yeah, I think public enforcement in the US tends to do that as well, rather than, I mean, occasionally you get this controversial disgorgement remedy that removes profits, but that only, as I said, eliminates the profits. It doesn't make it undesirable to try for them, I guess. Yeah. And most of our remedies, even, behavioral or structural ones, might at best would make the whatever self-favoring, neutral profit-wise, not negative. So I don't see how it would prevent it, except litigation costs, I suppose.
Can you tell us, Sebastian, hoping that we can hear you, can you remind us what were the 3 different remedies proposed by the claimants in streetmap.eu?
So I hope you can hear me.
Yes.
So the remedies that were proposed. So you remember there was about that little box that Google was showing where they showed their own map, so a link or the thumbnail to their own mapping service. And one of the proposals was that there would be 3 different links from 3 different mapping service providers, and then the consumer would click on one, and then they would show a thumbnail, and they would go on to the actual mapping. Another one was that they would show different, so 2 or 3 different thumbnails, so one of StreetMap EU, one of Google, and another provider. So these were the suggestions. The judge found that this was all a little bit too heavy-handed. He decided against it. He said, so this was basically a discussion that took place after he found no infringement, and they were just considering whether that could have been remedies. And he rejected all of those. He thought this would put a lot of burden on Google, so on the dominant player in the market, and to consider them inappropriate. So it brings us back to your question. So how would we design remedies when we have self-preferencing?
Mm-hmm. Exactly. Francisca, did you want to ask anything else that I see in your chat?
I'm sorry. No, I just wanted to, in case I don't have the chance to do it, answer to your remark that the judges maybe didn't deal with pass-on because the parties never alleged it. But
yes,
there are many cases where the parties actually did allege it, and where, in a way, it was stopped early before ever any quantification stage was reached. I've also talked to a number of economists that were very frustrated about this, that they actually had, in a way, the calculations ready, but it never came to this. So just in mind. I'm not blaming it all on the judges, but
yes, it's
sense
all
of the claimants, some did.
Thank you, Francisca. I will remember that. Thank you so much. Anybody else asking a question? No, Miguel?
I was just thinking, Paul, that, oh, sorry.
Yes.
Go ahead. Go ahead.
But, you know, there's a lot of talk in the U.S. about breakups, right? About breaking up these companies. And it's an interesting question as to whether...
Yes, yes. Please raise your question. Yes?
You want me to continue?
We could not hear you well, but now we can hear you.
Okay, sorry. An interesting question about whether, you know, drastic structural remedies like a breakup, you know, would deter this sort of conduct. I mean, even having that remedy out there. I don't know whether a firm like Google...
I'm sorry, Mark. We can't hear you well. Is there anything wrong in your microphone, whatever?
Doesn't look like it. I'll just type something in the chat.
Okay, okay. Miguel, did you want to ask any question? I saw that you were raising something at some point.
Yeah. I guess my point is quite more basic. I always get surprised in these debates, and we've heard that today in the presentations, that lawyers and judges keep discussing this as an issue of national law, and they keep quoting Spanish law and German law.
Yes.
And as I understand it, the last judgments of the court accepted the position put forward by the Advocate Generals, Niels Waal and Cocotte, that the requirements of civil liability are governed directly by EU law. They're a matter of EU law, and that includes passing on, that includes fault, etc., etc. And so I really don't understand why not. I mean, I know why, but my question was, among this group, is there clarity already that the requirements of civil liability are determined by EU law and have to be now clarified by the case law? Or is there still not clarity within the speakers about that? And following that argument is, when will courts start treating this as an issue governed by EU law and not by national civil law?
So what you mean is that whenever there is anything which is not clear in the case law, they should ask the Court of Justice to clarify?
No. I mean that they should stop applying the German civil code or the Spanish civil code or whatever, because that's not what governs these conditions. It's whether or not I am entitled to invoke passing on, whether I have to prove fault. That is an issue of EU law whenever an infringement of 101 or 102 is in question. It's not an issue of national law subject to the limits of effectiveness and equivalence. That's for the exercise of the rights, not for the existence of the rights.
Understand.
This has been made very clear in the recent case law, but courts still talk about it like it's an issue of national law.
Good remark. Now I'd like
respond to that, or
yes,
if we have time, or someone else wants to start. Since I'm the lady, I allow myself to go first.
This is reverse discrimination.
Yes, sorry. Opportunistic here. So I would disagree. I don't think it is as clear as you put it when it comes to, well, it's all a matter of EU law now. I think in particular with the last, I think that must be then Otis 2 judgment. I know the Advocate General was strongly advocating what you say, but I mean, the court judgment is extremely short, and I think to read into that it agrees with everything the Advocate General was putting forward, I think is a bit too strong. In particular, also because to my reading, it left it to the national court, which well, additional national requirements to establishing causality or not to consider. So that is, I think, in a way, the main problem, that causality is implicit in many of the figures that were created and harmonized at EU law, and that to my understanding is still very much left to the member states.
Jasper, do you want to
Yeah,
add?
I very much agree. I mean, this would have been a matter of EU law had the EU case law provided more guidance, and it simply hasn't.
Yes, hasn't yet.
Hasn't, well, yeah, that's wishful thinking to some extent, but it hasn't up until now. And Courage and Manfredi have allowed this to happen, pretty much. Yeah. With the damages directive still leaving open ends.
Yes, that's right. Can I maybe refer back to your question on the question of Mark concerning the structural versus behavioral remedies? I'd like to tell you about a case that we have now pending at the General Court concerning a big international sport association. You know that they are regulating the sport worldwide. In this case, it's the skating industry, the skating sport. And so basically, the Commission issued a decision on this on the basis of a complaint. It's public, saying that one way for that association to make sure that it doesn't discriminate anymore between non-members and members would be to get rid of all these pre-authorization procedures that they have. That is a system whereby whereby non-members can apply to this organization in order to organize events, and they can get pre-authorization. And so one of the possibilities which is envisaged by the Commission is to say, well, you can either apply your criteria and your procedures fairly, that will be a behavioral remedy, but we say, and for example, they use the word, for example, one way to ensure that this could be done would be to get rid of this system. So we see that in that decision, I'm not going to talk about the case pending, not the case before the court, but I'm only talking about what is in the decision. We see that the Commission is itself hesitating between the structural and the behavioral remedy, not knowing for sure what has to be done. And it remains a difficulty, yes. I'm not sure we will ever solve this problem, in fact. Mark, what do you think?
Well, you know, I think well, I don't know that case well, but I think, you know, there's always it's the same problem in any standard setting organization that involves market participants, right? And so it would always be better to split them, to split up the standards organization, or in this case, the sports association, from the members who have an interest in having it make a decision one way or another, except for the fact that, you know, such organizations depend on expertise. And in this case, you know, the approval presumably is justified based on some criteria that one needs expertise to evaluate. And so it's not just a competition problem. It's the age-old debate between conflicts of interest and expertise. You can't have one without the other, I think.
Okay. Francisca, you are asking, but I really like to do more research on UK case in the future. I'll be in touch. Okay, that's okay, fine.
Yes.
All right. So we still have 10 minutes. Does anybody have one more question that you or that you would like to raise? Somebody who hasn't had a chance.
We had Adriani mention or bring up a couple of good questions.
That's right. I think he's there online, as I can see his name. Adriani, can you?
I am. I hope you can hear me.
Can you? Yes. Can you raise
yes.
your question?
Yes. Thank you so much for the presentation. I'm really interested in the notion of fault because it's so complicated, so complex. It's not really clear what it means, and I guess I'm just wondering to what extent, indeed, fault as a requirement. The case actually of the EU court is consistent on the need for fault of some kind as a requirement for antitrust liability to arise, because I understand, at least based on my own reading, that this is a prerequisite in certain circumstances. For instance, you cannot find a cartel facilitator liable if you didn't have this mens rea element at play. And then in other cases, it's just not considered at all. So I think the case law is not entirely consistent on that. And my other question was whether, in your view, this presumption of fault will have the same content, because it seems to me here there are two different questions to consider. The first one is if we want mens rea elements as part of antitrust liability, so as a requirement for liability to arise in the first place, regardless of whether or not fines will be imposed. And then there is a separate question if mens rea or fault or negligence or whatever should be part of the tort claim. And I think I would agree with Miguel, who said that these are questions of legal law. I think I can see, I mean, the first one definitely, in my view. The second one, I also think if the question goes to the Court of Justice, it's quite likely that the Court of Justice will say, well, that's about substantive EU law. National courts shouldn't have any appreciation or room for a divergence in this regard. And the last question, perhaps more technical, but related to the previous ones, is how would you envision this rebuttable presumption of fault to be rebutted? Because you talk about excusable error, and is that excusable error in relation to the harm caused or in relation to the legality of the conduct? Because these are, again, different issues. So a lot of questions, but I really enjoyed the presentation. Thank you.
Thank you so much. Let me start off or focus on the last two questions, because I think the first one you pretty much answered yourself and has been discussed throughout this session. So what we argue is a rebuttable fault requirement related to the infringement. Right, and that is, so I'm looking at my second screen here, that is, you know, on a scale from irrebuttable fault to no fault required, to fault implied, so irrebuttably presumed, to fault in relation to effects, to fault rebuttably presumed. And we see that in most member states, fault is related to the infringement, and therefore a excusable error, in our view, would also be rather related to legality than to damages, to effects. And what the Commission itself has proposed here is the reasonable person test. Right, so a reasonable person with a high standard of care would not be aware of its own restriction in competition. And admittedly, I mean, I'm hard pressed to find concrete examples of that, but I'm not sure if it's actually necessary, because it's more of a safeguard in terms of due process and fair trial protection. You at least want to leave that option open for defendants that have genuinely excusable circumstances, even though I can't think of many circumstances in which that would happen.
Okay. Andriani, are you okay? Is there anything else you wanted to have an answer on? There was quite a bunch of questions that you raised, so I guess that everybody on the panel can take these questions and also for future reflection. now it's about time to conclude. It's 3:45. If I can give 30 seconds to each member of the panel to conclude, and then we can stop, actually. So maybe we can start in the order. That is first Jasper, and then first Sebastian, then Jasper, then Francisca. Sorry for the ladies. And then Ignacio. Yes, Sebastian.
Well, I think this has been a hugely fascinating discussion. When it comes to remedies, there's still a lot that we need to learn and to explore, especially how do we actually tackle things like self-preferencing, for example. What would be an appropriate remedy? Apart from that, the whole issue about passing on, that's something that in the UK is very, very dominant, or it will become very dominant with a lot of court cases. So I think in terms of private remedies, we will probably see more cases in the future. But there's also, it depends on whether we can solve some of the more substantive questions. Thank you. And thanks a lot for sharing.
Pleasure. Jasper.
Yeah, thanks to the chair, thanks to the other panelists. I think for me, the main point that I take going forward, or that we take going forward in this paper, is that it may be a good idea to take a more empirical route here, looking at actual damages claims based on fine issued EU law cases, and I really appreciate the pointers there from the audience. That would be an interesting next step to pursue the research, and I'm really appreciative for you pointing that out to me. So thank you all.
And don't forget, all of you, an outlet for the for Jasper's paper. Francisca.
Yes, I also would like to thank you all for your comments and for the ability to participate here today. But I would like to use this opportunity to stress once more the need for interdisciplinary research, really. I think these passing on example showcases that denial on the one side, approval on the other side, and pass on is not the end of the story. There are more damage components that have, like the volume effect, not been dealt with at all yet, and are even more complex. So we really need to invent something if we want to push through with the approach of full compensation.
Interdisciplinary and comparative as well, US, EU. So it's kind of difficult to have a common position in both disciplines and then across worldwide, in fact.
Yeah.
And then Ignacio.
Yes. Once again, thanks for being allowed to present. Thanks for sharing, and thanks for my fellow panelists, which, I mean, I was really honored to be able to be among you. And yes, I fully agree with Francisca, especially the part of the multidisciplinary research, since I am just a law-based PhD candidate. I am taking economics as a something fixed, that's what it is, and I am not really asking myself whether that's okay or not. And I mean, it was quite helpful to let me see that I should start trying to see whether to learn more about the economics to really understand.
Okay.
So thanks to everyone, and thanks, Francisca.
I'd like to thank all of you for your participation, particularly the panelists, of course, and the members of the public, Mark, Andriani, Christian as well, who's been very active. Yukun had been active. Sorry about that. I didn't give you the word. Miguel as well. But that will be for the next time. There are many more sessions in which you will be, have an opportunity to express yourself. I wish you all the best, and let's keep in touch.
Thank you.
Thank you. I'm going to ask maybe Sarah if there is anything that we need to know, that we need to do.
Nothing.
Okay.
All is done.
We can say goodbye to everybody.
The chat, maybe. I mean, is there a way to salvage that? Because I mean, there's so many interesting questions that I would hate to see those vanish now.
Actually, the saving chat option was disabled when scheduling the meeting, but I took photos and I will write it all down and send it to you, at least to the speakers.
Wow.
It will be incredibly nice of you.
Thanks.
If you have the time, really. Don't bend over backwards.
Maybe it will come in the beginning of next week after the conference is over. I'll see how I find the time.
Take your time, but that will be incredibly nice of you.
Let me take this opportunity, Sarah, to thank you also for all your work and your presence, your warm presence to make sure that everything is okay. And regards to Ruprecht. Thank you to all of you. Thank you. Bye-bye.
Thank you. Bye.
Cool.